now in session. The Honorable Adrian G. Sal, Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, well, ladies and gentlemen, good morning to each of you. As you heard our esteemed marshal as he opened court this morning, my name is Adrian Sald. I'll be presiding, and I'm privileged to be joined this morning by two of our distinguished judges. To my right, your left, is Judge Joseph Boatwright. To my left and your right is Judge Paige Kilbane, and we will be hearing the cases that are set for oral argument this morning. Before we proceed to our first case, I wanted to welcome the students from Atlantic High School's Academy of Law and Government under the tutelage of Margot Rivera. We're thrilled you all are here, and we're look forward to maybe saying hello at the end of the court's work this morning. The first two cases that we will call for oral argument this morning are the related cases of Weems versus Wedekin et al. Those are case numbers 233388 and 233390. Counsel, good morning to each and all of you. The court spoke at beginning our work this morning, and it's our anticipation that because the cases are related and involve substantially similar issues, that one oral argument will suffice so that you all may address both cases, but rather than 20 minutes per side, we will allot 30 minutes per side so that if there's any factual uniqueness to a given case, you all have sufficient time to address what you believe you need to address during the course of argument. Now, of course, allotting the additional 10 minutes per side does not obligate you to use that time. If you feel you can address it within whatever time afforded, then that's certainly up to you. For purposes of everyone who's here in the courtroom, if you would kindly ensure that your cell phones are turned off, not simply into vibrating or silent mode, that would assist us in the smooth operation of the court's proceedings this morning. Counsel, for each of you, customarily we allot 5 minutes for rebuttal argument. Should you wish additional time, then if you will let us know that as you begin your argument as appellant's counsel, then certainly we will make sure that the clock reflects the rebuttal time you all have indicated. With that, appellant's counsel, you're welcome to proceed.
Thank you. Good morning. May it please the court and counsel. Shane Vogt on behalf of the appellants, Charles and Carrie Weems and their company, Celebration Global. As your honors know from the briefing, Mr. and Mrs. Weems are husband and wife who started a church, a congregational church in Jacksonville, roughly a quarter of a century ago. And they came to the court system for help in early 2022 after they were ousted from that church, they believe improperly, and subsequent to being ousted from that church were also publicly defamed, including allegations against them that we have alleged are false, maintaining that they committed financial improprieties and actual financial crimes against their congregation and the church that they had dedicated a majority of their life to running, founding, and growing. And so the reason that they were turned away from the courthouse and that their own First Amendment rights to petition for the redress of grievances were denied was based, ironically, on the First Amendment itself and its protection.
What bearing would other clauses of the First Amendment have, such as the free exercise and establishment clause? What impact would those have as it pertains to the ecclesiastical abstention doctrine prohibiting our review or the lower court's involvement on those counts that were dismissed?
So obviously the abstention doctrine is well established, and it does trump access to the court systems when it applies. But in this case, we believe that it does not apply and that the trial court, unfortunately, erroneously decided that this was an ecclesiastical dispute in both of these cases. In the 3388 case, what we're talking about is tort counterclaims against several individuals for tortious interference with some contracts, which the trial court determined those contracts themselves were within the subject matter jurisdiction of the court, which raises an interesting issue, because our position obviously is that if the court has subject matter jurisdiction over contracts and whether they've been breached, then it should also have jurisdiction over individuals who have interfered with those contracts. And in addition to that, we had breach of fiduciary duty claims and conspiracy claims based on the ouster of the Weemses from the church. I think what gets lost sometimes here, and I think what got lost with the trial judge with respect to that case and those claims, is the focus got shifted to why the Weemses were ousted, whether that was for religious reasons, biblical reasons, doctrinal reasons, rather than how. And the claims that we've alleged here are focused on how they were removed. That's where the interference.
Isn't the why important, though, too?
For purposes of our claims, no. Because what we've focused on, because of the abstention doctrine, is the fact that the initial investigation and removal, starting that investigation, suspending Pastor Weems while it was occurring, and the entire process during that initial time period was improper because it wasn't in accordance with the bylaws.
How?
Because the bylaws establish a specific procedure as to how an investigation of the senior pastor can be initiated.
Is that through the overseers?
Yeah, it is through the overseers.
How many, and there's 3 of those?
There's 3 of those.
Pastors from outside the church?
Correct.
And how many were sitting at the time?
Only
or
one.
3?
Only one.
Did the bylaws provide any mechanism for the trustees to act in such an occurrence?
They did not,
Okay.
which is a problem. But given the fact that the bylaws, which in this setting involve a congregational church and therefore subject to Florida law as opposed to a hierarchical church, when that situation occurred, then Celebration could have done what the Weemses initially did, which was go to court and say, we have a problem. Procedurally, under basic law, this is a problem. We need to fix it. We think an investigation should be commenced, and the bylaws don't provide for what's supposed to happen in this situation. That didn't occur.
Are you saying the ecclesiastical abstention doctrine doesn't apply to a congregational church?
Not in total. And that was another argument that we made below that I think the trial court misconstrued. We've never taken the position that the abstention doctrine doesn't apply to congregational churches at all. What we've done is laid out several cases in our briefings and tried to argue to the trial court that when you have disputes about control of a church, I believe that the terminology that the case law uses is a schism. In a congregational church, courts can actually delve into those situations. There have been several cases in which courts and appellate courts have actually reversed dismissals based on subject matter jurisdiction under the abstention doctrine, because not only have they found is it appropriate to exercise jurisdiction in a congregational church setting when you have those types of disputes, but that courts have a duty under the law to do that. And it's important because in those particular settings, congregational churches, the people involved have nowhere else to turn. When you are part of a hierarchical church, Catholic church, Baptist church, there's a higher body that you can appeal to resolve the dispute. You don't have that here. The people who my clients allege came in and improperly took over the church, which is something that has to be presumed to be true, not just for purposes of our motion under typical motion to dismiss law, but there was no evidence submitted by the appellees below refuting any of the facts that we alleged. And so what you have here is a situation where the people who are alleged to have improperly taken control of the church are the ones who were adversarial to my clients. And they literally had nowhere else to turn to other than the courts for help, and they were denied. I understand why. We've never said that the abstention doctrine, the First Amendment's protection of religious freedoms is not important. It's incredibly important to my clients, as is their right to petition. But what gets lost in this is the focus a lot of times is only on the First Amendment rights of the religious institution. And people have a tendency not to appreciate the fact that those same rights are on the other side of the equation. My clients are the people who started a church 25 years ago now. That was their way of practicing religion. It was taken away from them. They lost that. And they came to the court for help after that occurred, and they were turned away. At that point, essentially, what the trial court is doing is siding with the faction that took over the church and prohibiting my client from practicing religion in the manner in which they wanted to. That gets overlooked a lot of times, particularly in cases like this one. And so that's why we tried to focus on the fact in our briefing that, so much of what the trial court determined, and if you actually look at the orders that we're talking about, there was a focus on the whys, as I mentioned, as to why certain things were done. And the fact that the court saw this as a dispute over who's going to preach from the pulpit and who controlled the church. And it's a nuanced issue, but at the end of the day, my client's only beef about who was going to preach or control the church had to do with the bylaws and compliance with those. And they had a right under the case law to go in to court and see whether or not those bylaws were complied with. And the court very well could have said, well, as our panelists noted, this was a situation that the bylaws didn't address, so I think that what they did was appropriate. And if that was the case, so be it. But we didn't even get to that point. And that, I think, is the problem here, is that my clients got turned away before that could even occur. And at least their right to get into the courthouse for that to happen was an incredibly important right that implicated several First Amendment protections that my clients lost as part of this process. And again, just to kind of wind up on the 3388 case, which is the counterclaims case, there's sort of two components to that. The one is whether or not the ouster, the coup, as we refer to it at times, complied with the bylaws. Sort of the second component of those claims that are issued in that case is the tortious interference with the contracts, which the trial court said it did have jurisdiction over. And I can determine whether or not these contracts exist and whether or not they were breached. And that was actually taken up on a petition for writ of prohibition to this court, which was denied. I think primarily based on our argument that it was premature, because there was a lot of defenses to that, supposed defenses to that claim hadn't been borne out yet, that the defendants were maintaining, well, we're going to need to argue things that are going to involve biblical issues, ecclesiastical issues, in order to defend those claims. But we're not there yet, and I think that was the proper course to take on that.
Your argument draws our attention and our focus to what you argue is the emphasis below of the process employed for the conduct of the church as it pertains to the Weems. But how would the claims for defamation and the like relate to, how is that process? In other words, defamation is not so much process-oriented compliance with the bylaws. The claims for defamation that your clients raised dealt with the publication of information to the church or online, leaking it to the press and the sort. Is that process-oriented, or is that something different?
Not process-oriented at all.
Okay, so in a
separate.
defamation context, right, and everything seems to trigger from or center around at least what is described in the report as an encounter during some sort of a Passover service or the like, and that seemed to be, if not the genesis of things, certainly a central part of the origination of the dispute. And what I'm trying to understand is if the emphasis is on process, compliance with the bylaws and the like, defamation claims, and I think there were 6 counts of that, seems to be different than process. And how would not then, if the defamation is raised, would the trial court not be obligated then to get into the context of basis of removal, truth of those matters presented in the report, that would involve the court then in ecclesiastical matters that are intra-church disputes, and therefore beyond the prerogative of the court, trial court, jurisdiction of the trial court, or even potentially competence to the extent it requires interpretation of Scripture, whether Scripture requires it to be brought to the attention of the church involving a pastor and the like.
So on the defamation claim, I want to make very clear that it has nothing to do with the process. We're talking about a report that was published on April 24th of 2022 after the Weemses has already resigned. They were no longer members of the church. They were gone.
But why does that matter?
Because at that point, they have religious freedom, everyone does, to leave a religious organization. And they, under the law at least, in the case law that we discuss, the church loses its ability to kind of pull them into the fold. Once they've left the membership of the church, it's a constitutional right, part and parcel with an individual's ability to practice religion the way that they see fit. That's one reason. But the second reason that that's important is because the publications that were sued over were outside the church. They were published on the church's website to the general public, despite the fact that we submitted evidence in the trial court that there was an internal communication system at the church where it could have sent the report to just members.
They did deal with incidents while they were attending the church, while they were running church, correct?
Pardon me?
I said they did deal with incidents that happened while they were either attending or running the church, correct, in church administration, not after they left.
Correct.
Incidents after they left.
The statements.
To follow on Judge Kilbane's question.
Yes, the statements were while they were involved in the church, the factual basis of the statements. However, the publication of those statements, which is the crux of the claims for defamation and invasion of privacy, occurred after they left the church. Florida case law, out-of-state case law, we cite the Ginn case in particular out of Oklahoma, has a significant discussion of this temporal issue with respect to when statements are published, but the Florida cases also talk about it. And I think that's one component of whether or not the ecclesiastical abstention doctrine applies to the claim. The second aspect of that that's equally important is what statements did we sue over? We didn't sue over statements that had to do with the encounter. We didn't sue over statements about his...
Those were removed in the amended complaint, right? In the second amended complaint, I believe it was?
Correct.
All right, so, but would that relieve, in other words, Judge Ajo's order seems to be fairly thorough, seems to be discerning as to what counts in the application of the ecclesiastical abstention doctrine and the like, but certainly if certain statements are the subject of a lawsuit, certainly the context of everything would still be relevant before the court, would it not?
It is. Absolutely it is. But what the case law holds under the abstention doctrine is that doesn't mean that the court is prohibited from exercising jurisdiction just because a dispute arises in the context of a church. Just because in order to address that dispute, it's necessary for the court or a jury eventually to actually look at issues involving the church, circumstances that occurred, that doesn't mean that abstention applies. If that were the case, you would never have a case that involves a church that would fall outside the abstention doctrine. And yet we have multiple cases, including from this court, where defamation and slander claims involving a church were determined to be actionable and not subject to abstention. There was subject matter jurisdiction over those. And really, what those cases focus on is the statements themselves and whether or not those statements and whether they're actionable can be determined without analyzing religious doctrine, biblical principles, or excessive entanglement in church doctrine. And here, the statements that we actually sued over can. They all have to do with financial improprieties. They actually include specific allegations that my clients committed financial crimes under secular law. and recommend that they be prosecuted criminally for those acts. That's all we've sued under in terms of defamation. Those types of statements are not subject to abstention. They're clearly, their truth or falsity can be determined by looking at basic facts and applying secular law. Did they steal money? Did they embezzle money or not?
The alleged financial mismanagement, did that deal solely with the movement of money from perhaps Celebration Church to other Weems ministries, Celebration Global, et cetera? Or did it go beyond the movement from money from one ministry to the other?
I think some of it had to do with the movement of money. We've actually have a detailed subparagraphs in the, I think it's a third amended complaint where we lay each one of those out. And some of them have to do with misrepresenting, mischaracterizing things as loans on financial statements. They're basic things that you don't have to have any analysis or any background in religious doctrine or theory in order to look at those and say, oh, okay, well.
So church governance doesn't come into play in any of these things? What about the Shellcracker Road property?
Well, the specific
Whether
statements.
they had the authority to do the transaction the way they did it, doesn't that have to do with the internal workings of the church?
Let me be careful how I say this. Does it have to do with the internal workings of the church? Yes. Is it asking a court to decide whether or not the internal workings of a church are proper or improper? No. Is it asking a court to direct how a church should or shouldn't do certain things financially? No. What it's asking is...
Asking that if you're saying that if the church is saying that the transaction is improper?
Well, you have to look at the specific statements that were made, and I'm trying to find the one on the Shellcracker property. But I believe...
I mean, I understand. I mean, I read the brief and read the publication. I understand they talked about embezzlement,
right,
and those type of things. I understand your point from the secular position, but still they have to analyze the inner workings of church governance, it seems to me, whether he had the authority to sell the property, how he could sell the property in the way he did. Is that correct or not?
I don't think you have to analyze governance itself in terms of an ecclesiastical perspective. You can look at the bylaws. Number one, you could look at the bylaws to see if the sale of the property was done in accordance with the bylaws. That's not ecclesiastical. And number two, you look to see if the board approved it, which again, it's not really, I don't want to go back and confuse things now by saying it's a process, but that's more process related, looking at, okay, did this occur? Was it approved? Did people know about it? Because what they've said is you embezzled the money from that.
So are you saying that this transaction was covered in the bylaws? Is that what you're indicating to this court?
It would be either addressed in the bylaws or approved by the board, one or the other.
And what if it's not?
If it's not, then I don't believe we could prove the falsity of the statement, because...
So you wouldn't ask the court to look at church doctrine or anything of that nature?
Not on those issues. And I think we were very careful in the third amended complaint, given Judge Aho's concerns, that what we focused on in terms of the defamatory statements were specific statements that were made about financial misconduct or financial improprieties that don't require any sort of religious doctrine or principles or anything of that nature to be applied. It would be if you took the statements that we sued over in the third amended complaint and look at them in the context of they weren't made by a church. I'm going to look at these statements, these specific ones. Take the church out of the equation. Would you need to go and look at religious doctrine to determine in another case if those specific statements were true or false? No. Absolutely not. You look at the bylaws, you look at the company at issue, approve them or not. That's how you would analyze it. And that's exactly the way that can occur in this case. And That issue, in and of itself, should result in there being subject matter jurisdiction over these claims when you look at the nature of the claims themselves. That's separate and apart from the fact that even if there is some, ultimate conclusion that, you just can't separate these things, they're too intertwined to get away from them, you still have the fact that the temporal aspect of this and the fact that it was made publicly outside the church is another avenue in and of itself to establish that there's subject matter jurisdiction. The church at that point has elected to make this a public dispute and take it beyond the confines of the church. It's not a traditional waiver argument. I don't want to give that impression. But if you look at the case law, the overwhelming majority of the case law in Florida and in other states finds the context of the statement in terms of when it was published and where it was published as being incredibly significant.
And are you referring to the Flynn case again? Is that what you would say is the best case supporting that temporal position?
I think the Flynn case out of Florida, but then if you look at all of the other out-of-state cases that we cited that actually sort of jive in with Flynn, some of those, quite frankly, have a more detailed analysis of the issue than Flynn does, but they all follow the same law as Flynn and as Florida. At the end
You're not saying that Flynn itself actually puts this first step analysis in there, are you?
No, I think if you actually look at the language in Flynn and what it determined, it was part of the analysis for Flynn.
It seems to be a bit of an overread, no, to say that because they said one thing, you can infer the opposite from that? Because that's essentially what you would have to do to find that Flynn supports that position, no?
I can understand Your Honor's position on that. I do think that the fact that when you read Flynn in the context of other decisions from other states, it becomes more clear that call them extra church statements are going to be actionable. Because it's important to keep in mind, we're talking about the First Amendment. So yes, I appreciate Florida law is binding on the court, but you do need to look outside occasionally for some guidance there because the First Amendment should be universal. It should be the same in every state. And so, there's no distinction there. Florida, obviously, its Constitution has a First Amendment right and protection of religion, but when we're talking about the First Amendment, it should be fairly consistent across the country, and that's why I think those authorities are particularly persuasive when you look at them in the context of Flynn. And factually how the other cases are, and it makes sense at the end of the day. When you have a statement that's made publicly, put on a website for the entire public to see, and leaked to the press, which again is another fact that was not disputed and no evidence was submitted to refute. And we're fairly confident about that fact, by the way. But when that occurs, this isn't a church dispute anymore. It's a public dispute. It went beyond the confines of being religious at that point.
And counsel, you're 30 seconds into your 5-minute rebuttal.
Okay, thank you, and I'll stop there.
All right, sir. Thank you.
Morning, Your Honors. May it please the Court, Timothy McGinn of Gunster on behalf of appellee Lee Wedekind and presenting on behalf of appellees generally this morning. Before I get into my argument, I do want to clarify a couple of key factual points. First, this is not a schism case. The Weemses resigned from Celebration Church. It started as a schism case. The Weemses originally brought a complaint seeking injunctive relief to stop the amendment of the bylaws, which the board had to amend in order to resolve the conflict Your Honors alluded to earlier, that there were no overseers who had been properly appointed to oversee the investigation that they were calling for. The Weemses attempted to stop that with their original complaint, but then they withdrew that complaint, amended it, and resigned from the church. So this is not sort of that paradigmatic case where you have two factions of a church, each of which is claiming itself claiming the mantle for itself of being the true church. The Weemses founded the church, but they're gone. There's no question about who Celebration Church is, who represents Celebration Church. It's the current board of directors. It's the current pastors. It's the defendant appellees in this case. So there's no question about resolving who is Celebration Church. The Weemses have resolved that question for us by resigning. The second issue, and it suggests that there's a need for intervention by this court because there was nowhere else for the Weemses to turn. There was no other authority to whom they could appeal. And that's a problem with the ecclesiastical abstention doctrine generally, but it's not actually a problem in this case because the bylaws themselves provided an additional authority to whom the parties could appeal. And it was not the civil court in Duval County. It was to participate in the Christian mediation and arbitration process. The bylaws that were originally drawn up by the Weemses themselves as the founders of this church recognized that this was a congregational church to whom there was no higher authority baked into the process already, and the church and the Weemses decided that their disputes were not going to be resolved civilly. They were not going to submit to the jurisdiction of a secular court, but they were going to go through Christian mediation and arbitration. So this is not a case where, the parties are crying out for an additional authority to come in and settle their disputes. If the Weemses wish to use the provision that they themselves put into the bylaws as founders of this church, then they may avail themselves of it. They have a remedy. They have an avenue for redress that others might not have by virtue of this doctrine. So just wanted to clarify those 2 points at the top. So the standard, as Your Honors is aware, and the reason why this court and why secular courts generally do not have jurisdiction over this dispute is because the ecclesiastical abstention doctrine precludes any secular court review over claims arising from church discipline, internal organization, and governmental disputes. And that's what we have here. And I think the Weemses, to their credit, have attempted to draw their claims as narrowly as possible to avoid the application of this doctrine. But there really is, to the questions that were asked by the panel of appellants counsel earlier, there's no separating the how from the why. You don't understand this dispute. You can't resolve this dispute unless you address the why.
In the report, it states that they embezzled profit. Why is that not purely a secular matter? When I think of embezzlement, I think of more of a secular concept.
Well, the question of embezzlement turns on, in part, authority. It turns on who has the authority to act for the church, what regulation they are subject to, what supervision they are subject to. And the transaction is listed in a series of transactions in the report that are described as improper financial transactions, and they're improper from the perspective of a church. They're not necessarily improper from a secular perspective.
What about the misappropriation of the PPP loans?
That, from the perspective of the church, the question is, was that proper? Was that properly supervised? Was that...
There's set in place rules that have nothing to do with the church on how to appropriate or distribute or manage a PPP loan, correct?
There are federal regulations about how that money was supposed to be spent, yes, but there was also the related question of who was supervising and what supervision was Pastor Weems submitting to when he was engaged in these transactions. They didn't happen in a vacuum. He was supposed to be subject to the oversight and discipline of the trustees who were unaware of this conduct. So any engagement with that question, it's not just going to be a question of, well, how did he spend the PPP money? It would also necessarily involve the questions of, what was he telling other people in the church? What did the directors know? To what extent had he obtained their approval? And these are not questions that follow the same secular rules. The questions of agency, for example, as I believe this court addressed directly in Napolitano, by applying sort of a secular notion of agency, of internal organization to a church, would allow the secular court to co-opt to co-opt the religious organization and to impose different standards, a different world outlook than the church might otherwise adopt for itself. And that's really the problem here. These are improper financial transactions. Perhaps they would be secularly improper as well, but from the perspective of a church, from the perspective of a board of directors that is charged with overseeing the spending of tithes, of other sacred offerings that are being made for the benefit of the church, the question of what is proper versus improper is a very different question than it would be if this had been embezzlement, if this had been improper spending by the director of a bank or the president of a bank who had been pulling the wool over the eyes of the other directors, because a bank serves a secular purpose. The church, its pastors, its directors, its overseers, all come at this from a very different perspective. They come at it from this religious perspective where they are to serve the needs and purposes of the church. And so what is proper for example, this Celebration Church, an investment in a speculative cryptocurrency, the spending of PPP funding. It's all supposed to serve the church's ends. And so what is proper from the perspective of the church is necessarily tied up into any inquiry over whether these statements were false and defamatory. It's inescapable because of the church's outlook and perspective and purposes. And that piece of it is not just sort of a gloss that we are adding to it. It's baked into the elements and the basic defenses of each of these claims. For purposes of the defamation count, for example, since that's where we started, there's a question of, were these statements made with actual malice? What was the purpose for which these statements were made? There's no way to get into the actual malice that was supposedly had by the individual defendants without a comprehensive understanding and investigation of what it was that they knew about the pastor's conduct. And there's no separating what they knew about the pastor's conduct from the other facts that led the report to conclude that the pastors had engaged in unbiblical leadership and had demonstrated that they were unfit to be pastors moving forward, which is, you can hear it in the characterization of the conclusion. Unbiblical leadership, unfit for pastoral responsibility. These were religious and spiritual conclusions, even if...
A quintessential ecclesiastical question.
Absolutely. I couldn't have put it better myself, Your Honor. That's exactly right. The question
The
of whether...
report at issue cites numerous Bible verses, scriptural references, the like, as it pertains to their findings, their recommendations, reasons for reasons for publication and the like, all of that. The report seems to tie to a biblical purpose and outlook for all of that. Am I mistaken?
You're 100% correct, and it was that way by design, as the report discloses. It was undertaken for biblical purposes. It was a biblically led, church-led investigation. It was not intended to be sort of a run-of-the-mill, outside counsel, internal investigation report. This was Bible-driven. I cannot, in my years of practicing law, cannot recall another internal investigation report that I've seen in which the subjects of the investigation were accused of something akin to Gnostic heresy. And that's what we're talking about. It's a key section of this report.
What about where your opposing counsel raised that they violated the law? I assume that's secular in nature. How is that not secular? Why do we have to delve into church doctrine to figure out whether he committed a crime or not?
Well, it's inseparable. So the question there becomes, when you have a defamation count, the question of substantial truth is always in play. And you look at the gist of the statement. Would the statement as made have a different effect on the mind of the listener, on the mind of the reader? Would the statement have had a different effect, removed from its context? And here, so you have to look at the entire context. And so it's impossible to separate out just that one fraction of a statement and say, oh, well, this was a crime, from the larger accusation that the pastors had mismanaged the church's finances. You'd have to ask, would a juror think differently about the Weemses, having read all of these other sort of accusations of biblical mismanagement of church funds, this misstewardship of church assets, of donations, of tithes? Would they have felt one way if they read those and then felt a different way if they had read those accusations, but also the accusation that perhaps the embezzlement was also a crime. And so in asking that question, you necessarily need to get into all of the other accusations and allegations of financial impropriety that arise entirely within this church context and that turn entirely on the purposes for which this money was donated, collected, and to be spent. So even if cherry-picking little pieces of the allegations would allow you to present them, as the appellants do, as being indicative of secular wrongdoing and only secular wrongdoing, it's impossible to separate them out because you have to consider the gist of the statements, the effect on the mind of the reader, and also whether or not these defendant appellees acted with actual malice, whether they knew what they were saying was false, and considering the broader context in which these disputes arose. And you simply cannot separate out the fact that this dispute arose in the context of Pastor Stovall Weems's encounter with the risen Christ at a Passover Seder and his subsequent behavioral changes and his taking the church in a different direction following that encounter. There's no way to separate out that context. And if you can't separate out that context, then any inquiry into the propriety of what he was doing becomes barred by the ecclesiastical abstention
Were
doctrine.
some aspects of movement of money belonging to the church done in furtherance of the encounter and what I guess was asserted to be the direction given to the Weems to take the church? Did that lead to some of the money movement between ministries and the like?
From the report, which is what we're basing all of this off of, from the report it seems as if everything that happened in Celebration Church was informed by the encounter and what Pastor Weems said he had been instructed to do by the risen Christ with regard to the future of this church, what God had in mind for him, for his family, for this church. It was all driven by that message that was known only to him, and that was shared, according to the report, was shared in part only by him to limited other members of the church as it served his purposes. So there really was, according to the report, no separating governance of the church from Pastor Weems's encounter with Christ and what he learned during that encounter. It's inseparable. It will any inquiry into any of the claims that are raised by the pastors in either of the cases is necessarily going to raise that question of what happened and what became of Pastor Weems, his behavioral changes, his changes for the church in the wake of the encounter that he says he had. There's not going to be any way to separate that. So you're going to, I can think of few better examples of places that a secular court in this country should not go than looking into whether or not the pastor of a church had an encounter with Jesus Christ and what it was that Jesus told him was the future for his church. Simply cannot go there under the ecclesiastical abstention doctrine. It's not a close question. With regard to the fiduciary duty and the tortious interference claims that are the subject of Appeal 3388, it presents a similar issue. The religious aspects of the inquiry are necessarily baked into the claims. There's no way to separate out the question of whether or not the church acted appropriately from a religious perspective, whether or not the Weemses acted appropriately from a religious perspective, from the claims themselves. So with regard to fiduciary duty, as the court is aware, the question of whether a duty is owed in the first place turns on the specific factual situation surrounding the transaction and the relationship among the parties. These parties have no relationship outside the context of the church. The duties that the Weemses allege are owed to them as ministers by other pastors, by the directors of the church, by the church officers. There's no relationship between these individuals outside the context of the church. So you're necessarily going to get into matters of church internal organization, church governance. There's no avoiding that issue. And again, that specific factual context in which these duties were supposedly owed turns on the encounter with the risen Christ, the alleged heresy by Pastor Stovall, and the alleged unbiblical leadership of the appellant pastors. I think the Gallagher case is a good example from the Fourth DCA about why this is improper. To determine what a priest's duties are, the Fourth DCA held, would excessively entangle the court in questions of religious administration and government and the procedures and dictates of, in that case, the Catholic faith. That's exactly what the pastors are asking this court and the trial court to do, to look into the duties of these different officials within a religious organization and to determine whether or not the church abided by, its members abided by those duties. That is asking the court to substitute its own judgment for that of the church.
So as you reference respective duties of trustees and other officers or pastors, what authority did the trustees rely upon in taking action when there were not 3 positioned overseers who could otherwise conduct and initiate an investigation?
Well, they engaged counsel, but they also invoked their right to amend the bylaws. So they amended the bylaws to conduct the investigation in the absence of properly appointed overseers. So they did avail themselves of the proper mechanism for amending the bylaws. But again, that's also not the subject of this dispute anymore. There was a claim turning on whether or not the bylaws had been properly amended, but that's been amended out of the complaint, several versions of the complaint ago. It's not proper for, the court has to look to what the actual dispute is. This is a defamation dispute. It's a tortious interference with contract dispute. It's a breach of fiduciary duty suit. It is not a question of whether or not the church properly amended the bylaws. That question was raised and then was dismissed. The Weemses have abandoned that claim. With regard to tortious interference, again, there are a few elements of tortious interference. There are a few defenses with regard to any effort to bring a tortious interference claim against an individual rather than a corporate entity that necessarily implicate not just the how, but the why. Tortious interference requires unjustifiable interference, which this court's precedents have explained is a highly fact-dependent inquiry that requires examination of defendant's conduct, motive, and the interests it sought to advance. There's nothing more entwined with the faith and internal governance of Celebration Church than the motive of its directors, the motive of its pastors in seeking to protect the church from what they saw as the ill influence of the founding pastors. The question of why they acted requires a forbidden inquiry. It requires a secular court to ask, why was it that the pastors of this church, the founding pastors of this church, were being ousted? Is it because they had engaged in improper leadership of the church, because they were poor stewards for this church and its congregation? Or was it out of malice? And there's no way to answer that question without getting into all of these improper areas of inquiry that we've discussed. It also requires to hold an individual defendant liable, and all of the appellees here are individual defendants. In order for an individual defendant to be held liable for tortious interference, they have to have acted solely with ulterior purposes and without an honest belief that their actions would benefit the church. Again, these questions of motive, their reasons, you can't separate out any of the religious context in which the pastor's claims are raised. You can't just focus on the how. You can't just say, was there a contract? Did they interfere with it? The court must ask why in order to find for the plaintiffs. And there's no way of asking why without getting into all of these improper areas of inquiry. I would also note that with respect to appellate Wedekind specifically, he had a qualified privilege to speak to the church, to publish to the church. And again, that qualified privilege protects him unless he acted in bad faith and solely for the purpose of gratifying his personal malice towards the plaintiffs. Again, the why is inescapable. It's baked right into the claims. I'd like to briefly, just on the subject of the defamation claim, just address the two points that are particularly raised by the appellants. One is that the statements were made publicly and that the church and its officers and agents lost the benefit of the ecclesiastical abstention doctrine by virtue of the public nature of the statements. And second, that because the Weemses had resigned, any subsequent publication is not entitled to the protection of the doctrine. I think the most important point for understanding this is that regardless of to whom the statements were published, and regardless of when they were published, any claims still raise the improper areas of inquiry. This, as this court noted in the Napolitano case, the ecclesiastical abstention doctrine and the First Amendment, the Establishment Clause, these are structural barriers. They are structural barriers between the secular and the religious. This is not a privilege. This is not a protection that can be waived by any one individual. It exists for the benefit of all to preserve that division between church and state that is found in the First Amendment. There can be no waiver. As the plaintiff suggests, though they don't necessarily call it waiver, that is what they are suggesting. And even if the statements were made publicly, even if they were leaked to the media, even if they were made after the Weemses resigned, they still raise the same questions. They still require the same improper inquiry into matters of church discipline, matters of church employment dispute, matters of church governance. The fact that the statements may have been reported on by the media doesn't change that. The fact that the Weemses said, "I resign," right before the statements were published doesn't change that area of inquiry. Now, I would say that to the extent that any Florida courts have addressed the question of scope of publication, whether or not publishing to the press robs a statement of the protection of the ecclesiastical abstention doctrine, Florida courts have held that has no effect on the application of the doctrine at all. And I would cite again to the Gallagher case. Gallagher is a fourth DCA case where the statements were published by the Diocese of Palm Beach, not just to parishioners at church, but they were posted online, and there were statements made directly to the media. And as the U.S. Supreme Court has recognized, a church is entitled to speak to the world, is to have the freedom to speak to the world in its own voice. By drawing an arbitrary distinction between publication directly to parishioners and parishioners only, or congregants and congregants only, and publishing more broadly, this court would be setting a rule that would chill expressive speech and speech on behalf of a church to its congregation. It would be interfering with a church's ability to speak to its members. And in this case, it would be chilling a church's ability to speak to its members on a subject of vital importance. The relationship between minister and church has been described as the lifeblood of the church. And what the appellants are asking this court to do is to say that if a pastor leaves his flock, the founding pastor of a church leaves because he's engaged in impropriety, that the church is not allowed to communicate that fact to the congregation that's likely to be shaken by this departure. They can't speak to the congregation without the risk of being hailed into a secular court for review by a civil tribunal. It's entirely inconsistent with First Amendment jurisprudence. It's inconsistent with the standard that has been drawn in this district, in the Napolitano case, where the holding of Napolitano was recognition that no state authority has the power to interfere in matters of ecclesiastical government, tracing back through a whole line of Supreme Court cases. And that's exactly what is being requested of this court, to interfere in matters of ecclesiastical government, in matters of just explaining to congregants the fate of their church, the fate of their founding pastors. So for those reasons, in the absence of any other questions, I would submit that Judge Aho got this exactly correct. She drew the proper lines in light of prior Supreme Court precedent as aptly summarized in the Napolitano case, recognizing that the Weemses' claims all arise from disputes over internal organization, church discipline, and governance, that this is simply not an area in which a secular court may go. She properly dismissed each of the claims that is at issue in Appeals 3388 and 3390, and in the absence of any further questions, I will simply ask that the court affirm. Thank you.
Thank you, counsel.
I know my time's limited, so I'll try to go quickly. On the notion that just because the court has to examine the religious context in which these claims arose automatically means that the abstention doctrine applies. That's wrong. It's legally wrong. This is a quote from the Mobley case. A lawsuit does not, of course, become a theological controversy just because one of the litigants is a church. And a First Amendment violation does not occur anytime a case requires a court to examine church law or policies. It's exactly what we have here, even under the appellee's version of this argument. I don't think you have to examine church policies at all or whatsoever to evaluate these statements. And I went back and pulled them from the report. This is what we sued over and what they say. Stovall-Weems, this is at page 20 of the report, violated the law, not biblical principles, the law, by breaching his fiduciary duties to Celebration, committing fraud, unjustly enriching himself at the expense of the church, and failing to meet the fiduciary duties and standard of care required by his office. Those are all the things he did to violate the law. He has brought Celebration to the brink of insolvency. You don't need religion to figure that out, whether it's true or false. It mentions the excluding the embezzled profit from the shell cracker sale. You don't need religion to figure out whether someone embezzled. In the findings of fact section, this is page 6, Stovall-Weems engaged in a series of improper and unauthorized financial transactions through which he personally benefited, either directly or indirectly, at the expense of the church. He failed to present these transactions to the board for its review and approval, which he was required to do pursuant to Florida law. I mean, we can debate and sort of get lost, but this is, again, why I kind of went back and focused on what they actually said in here, going right up to the conclusions where they say that one of the recommendations is that these findings be reported to the appropriate authorities to determine whether criminal charges should be brought. That's not religious doctrine, that's secular. And so when you look at cases like Mobley as well as Bendross, plaintiffs are not categorically prohibited from ever seeking redress from courts solely because a religious organization is somehow involved in the dispute. Another important issue here is in their brief, they actually concede that these issues that we've sued over involve secular issues. It's in the answer brief at page 33. This is a quote. The pastors were likewise disciplined for both the financial misconduct, parentheses, which violated both secular law and the church's biblical principles, and their unbiblical leadership. We only sued over the secular law part. And as Bendross and Mobley tell us, the fact that it may violate both secular law and biblical law, it doesn't matter. And actually, the abstention doctrine applies when those two concepts don't require the same thing. So in other words, if we were suing over something where biblical principles said he was required to do X, and the law said he was required to do Y, then we would be in a situation where abstention would apply. Here, according to the appellees, secular law and biblical law say the exact same thing. So they've been defeated on that. There was a notion that somehow the amendment of the bylaws isn't a part of this case. It is. It's in paragraph 97 of the counterclaim, which again is a counterclaim brought in response to an action that Celebration brought, not us. Paragraph 97, his suspension was wholly improper and violative of multiple Celebration bylaws. Aware that their actions were improper and they had no right to dismiss him, they unlawfully conspired to amend the bylaws to give themselves absolute unchecked power. That happened January of 2022, months before this report was finalized. And so I just think the devil's in the details here. And we've tried to be very specific with what we've alleged and what our claims are based on. And we think that as a result of that, the abstention doctrine does not apply here. Thank you very much for your time today.
Thank you, counsel. And counsel, we appreciate the well-presented, well-prepared arguments in the case. We will take those matters under advisement. Thank you all very much.